Hello and welcome to my channel Happy Hours. In the last video we discussed about union and its territory, article number 1 to 4 and about the linguistic states. Today we are going to discuss about the part 2 of the Indian Constitution, which is about the citizenship. Now we should understand first who lives in a state. An individual lives in a state either as citizen or as alien, where alien means of friendly states or of enemy state. During the war only we can say that these countries are our enemies. Now we should understand who are the citizen. A citizen is an individual who enjoys free membership of a political community. That is, he or she enjoys all the political and legal rights. Now we should understand what are the rights which are exclusively enjoyed by the citizen of India. The first right is right against discrimination, article number 15. Right to equality of opportunity in public employment, article number 16. 6 democratic freedoms enjoyed under article number 19, clause 1. Cultural and educational rights, which is also known as minority right, article number 29 and 30. These are the fundamental rights enjoyed by citizens. Now the other two rights are right to vote, article number 326, and right to hold constitutional offices under various provisions. Now we are going to proceed with the other topic, which is the constitutional provisions with respect to the citizenship. The Constitution has not elaborated provisions with respect to citizenship. Article number 5 to 10 talked about only three things. First, who at the commencement of the Constitution was a citizen of India. That is, by the date of 26 November 1949, who were the citizens of India. The citizenship is acquired in two ways. First, by domicile, which is described in the article number 5. There, three conditions were mentioned. First, who was born in the territory of India. Second, either of whose parents was born in the territory of India. And the third, a person who has been ordinarily residing in the territory of India for at least 5 years before the commencement of the Constitution. Now we are going to understand about the migration mentioned in the article number 6. A person who has migrated to India from the territory now included in Pakistan, dated 19th July 1948. The second condition is it prohibits dual nationality, that is, an Indian citizen cannot simultaneously hold the citizenship of another country. 3. Article 11 authorizes the Parliament to make any provisions with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Fourth, accordingly, the Parliament passed Citizenship Act 1955, which has been amended from time to time. Fifth, the Citizenship Act 1955 has amended in 1986 and 1992, provides for 5 modes of acquiring Indian citizenship. Now we are going to discuss about the modes of acquiring Indian citizenship. This can be acquired by 5 modes. First, by birth. Second, by descent. Third, by registration. Fourth, by naturalization. Fifth, by incorporation of new territory. Now we are going to discuss about all these in detail, one by one. By birth. A person born in India at the time of his birth, one or both of the parents are an Indian citizen. So there are two conditions. First, a person born in India and at the time of his or her birth, one or both of the parents were Indian citizens, which is also known as jus soli, law of the soil. Second one, by descent. A person born outside India and at the time of his or her birth, one or both the parents are Indian citizens. It is to protect the interests of the people who are born in other countries. There, one thing the parents has to do is the child has to get registered in Indian embassy or Indian consulate within the birth of 2 years. It is also known as jus sanguine, law of blood. Third, by registration. Certain categories of people can apply for Indian citizenship by registration. A. The persons of Indian origin, PIOs. B. Persons married to Indian citizens. Third, minor children of Indian parents. Such categories of people will have to fulfill the residential qualification of living in a country, India, for 5 consecutive years, which means 90 days per calendar year. Now, fourth condition is by naturalization. Any person not falling under the categories 1, 2, and 3 can apply for Indian citizenship by naturalization. They will have to fulfill the residential qualification of living in India for 12 years. Again, the same meaning, 90 days per calendar year. For example, we can have Mother Teresa. Fifth one, by incorporation of a new territory. When a new territory is acquired by India, its people are offered Indian citizenship. And if they accept the Indian citizen, the government of India is bound to give them Indian citizenship. Example is Puducherry and Sikkim. Now, as a note, we can understand in case of registration and naturalization, fulfilling the residential qualification makes a person eligible for Indian citizenship, but he cannot claim the Indian citizenship. It's not like that. If you are fulfilling the condition, you are given the citizenship. Now we are going to understand the different modes by which Indian citizenships can be lost. Indian citizenship can be lost by 3 modes. First, by renunciation, second, by termination, and third, by deprivation. We are going to understand these 3 one by one. The very first is renunciation. If a person voluntarily surrenders the Indian citizenship on acquiring the citizenship of another country, if suppose we are getting the citizenship of any other country, we have to surrender the citizenship of India. So our citizenship is terminated. And the second one is termination. If a person on acquiring the citizenship of another country does not voluntarily surrenders the Indian citizenship, and if the government of India comes to know about it, his or her citizenship can be terminated. Means when by mistake if you have got the citizenship of another country and you have not surrendered the Indian citizenship, and the Indian government comes to know about it, they can terminate your citizenship. Now we are going to understand the third and the last one is by depriving. A person can be deprived of his Indian citizenship by an order of Government of India if 1. If the certificate of registration or naturalization is acquired by fraud or by concealment of facts. Second, if a person within 5 years of acquiring the Indian citizenship is convicted for at least 2 years of punishment. It can be by any court of the world. Third, if a person had illegally communicated with the enemy during a war in which India was involved. This is the highest criminal offense of India, and it is applicable for everyone. Fourth, if a person is ordinarily residing outside India for 7 years and during these 7 years he or she was never a student in any institution nor employed under the Government of India or in any institution of which India is a member, or nor shown his intention of coming back to India and to retain his or her Indian citizenship. So what these people has to do is that every year they have to visit embassy or consulate. This is for the people who are not a student or working in the recognized institution of any country and residing. There is a process of deprivation, and we are going to discuss about that process of deprivation. A person can be deprived of his or her Indian citizenship after an inquiry is conducted by a committee headed by a person who has held a judicial office in the country for at least 10 years. Now we are going to discuss about the dual citizenship for the OCI card holder. The very first step was taken in the year 2003 when the Citizenship Amendment Act 2003 is provided a dual citizenship for the PIOs living in 16 countries. The Citizenship Amendment Act 2005 provides for the dual citizenship for the PIOs and OCIs across the globe. In the year 2015, the PIO card scheme was merged with the OCI card scheme. Now we have to discuss about the benefits of the OCI card holder. The OCI card holder can come to India without a visa, means they can have multiple entries. He can buy properties in India except agricultural and farmland. He can invest directly in the projects in India. But he has no political rights and he cannot hold office in defense services. Now as a note, we can understand the citizens of Pakistan and Bangladesh and any other countries as notified by Government of India from time to time cannot apply for the dual citizenship of India due to economic reason. Citizenship Amendment Act 2019, which is a very controversial question. Which we have to understand. This act seeks to give fast track citizenship to the Hindus, Jains, Sikhs, Buddhists, Christians, and Parsis who have illegally migrated from Pakistan, Bangladesh, and Afghanistan as they face persecution on the ground of religion in these countries. The cutoff date was kept as 31st December 2014, that is, a person belonging to these communities who has come to India on or before this date from Pakistan, Bangladesh, and Afghanistan will be eligible for fast track citizenship of India. They are to be given Indian citizenship in 6 years, but presently the Citizenship Act provides for citizenship by naturalization for people who have lived in India for at least 12 years. As a note, we can understand the Act is not applicable to the tribal areas of Assam, Meghalaya, Mizoram, and Tripura. It is also not applicable in Arunachal Pradesh. By this, I conclude my video here. We will proceed further in the next video. Thank you.